Good day, sir. I'm Rebecca, and today I'm going to present the legal aspects of fittings and fixtures in property sales. In the world of property law, understanding the distinction between fitting and fixture is essential in determining what is included in a property sale and what is not. Today, we will explore a case involving a property buyer, Abraham, who found himself in a dilemma with the property owner, Brenda, regarding the inclusion of paintings and sculpture in the sale property. So, before we move further on the discussion, let's see what Abraham has to say about this.
So, here's the thing. Last month, I saw this ad for a Victorian-style property that I absolutely fell in love with. It was like something out of a dream. So, I reached out to the owner, Brenda, and set up a visit. As soon as I walked into the property, I noticed that the place was decked out with all these fancy paintings and stunning sculptures from the Victorian era. I mean, it was like stepping back in time, leaving me impressed and wanting to own them myself. So I asked Brenda if they were included in the sale, and she was all like, "Oh, we can talk about it if you seal the deal right now." And I was like, whoa, hold up, lady. Let me think about it first, and the price was a bit steep too. The following week, I decided to purchase the property. But during the finalization of our deal, I completely forgot to bring up the inclusion of paintings and sculptures in the sale of the property, and Brenda didn't mention it either. Fast forward 6 months, I was finally ready to move in, and guess what? The paintings and sculptures are gone. I was livid. Brenda had pulled a fast one on me. When I confronted her about this, she claimed that they were just chattels and not part of the property, and she asserted that it was never her intention. She also pointed out that they were not included in the agreement either, as the value of the paintings and sculptures was high, so it wouldn't make sense for her to include them together with the sale of the property. Is she kidding me right now? Can you believe that? I distinctly remember us discussing it. Oh, come on, we had a deal. She promised. I should have known something was up. Now I feel like I've been scammed. What do you think I should do now?
Now that we have heard Abraham's first-hand account of his experience, and from what he said, I found that there are two key issues at play. One is the removal of paintings and sculptures when Abraham moved in, which Brenda claimed that they are just shadows, and another one is Brenda's vague reply when he inquired about their inclusion, which Abraham claims that an ambiguous response led him to enter into the contract, unaware that these items will be removed later. So the questions arise as to whether the items are fittings or fixtures, whether Brenda had a duty to disclose the truth about their inclusion when asked by Abraham, and whether Brenda induced Abraham into the property sale contract. To look further into this issue, let's delve into the complexities and legal aspects surrounding fitting and fixtures in property sales. Firstly, let's understand the concept of fixtures and fittings. In property law, fixtures refer to items that are attached or fixed to the property in such a way that the items physically lost their value as chattels and become part of the land and therefore property of the landowner. This was summarized in Latin maxim, quid plantator solo sed. It means that whatever has been attached to soil belongs to soil. This maxim is primarily used to define the rights of a landowner over things that are attached to his or her land. The case of Holland vs. Hodgson lays down principles so far as ascertaining whether objects attached to the land are fittings or fixtures. Blackburn J. stated in his judgment that any item attached to the land, even minimally, is presumed to be part of the land unless evidence suggests it was intended to remain a chattel. The burden of proof rests on those arguing it is a chattel. The categorization of an object as a fixture or a fitting is determined by components such as the intention of the parties involved, degree of annexation, and the purpose of the items attached to the property, as established in this case. However, the strategy was initially twofold. Firstly, the degree of annexation to the land must be examined, followed by the purpose of the annexation. The degree of annexation refers to how affixed the object is to the property. On the other end, the purpose of annexation examines why the item is affixed, considering whether it was intended to increase the value of property or for the better enjoyment of the item annexed. Blackburn J. further illustrated this with an example of blocks of stone stacked to form a dry stone wall, which become part of the land, even without mortar or cement. Conversely, if the same stones are stacked in a builder's yard merely for convenience, they remain chattels. Apart from that, when it comes to fittings, they are generally movable items or chattels that are not permanently affixed to the property and can be easily removable without causing any damage. For example, in the case of Lay vs. Taylor, the court ruled that some tapestries were never intended to be an integral part of the property, which can be removed by the rightful owner. Therefore, if the items are insubstantially fixed, then it is a chattel. Now, how the law applicable in this scenario? Therefore, in Abraham's case, if we wanted to decide whether the paintings and sculptures are removable or not, the first consideration should be to decide whether those items are fixtures or fitting. To determine that, annexation test should be applied as well. So firstly, let's talk about the paintings. Since the paintings are described as easily removed, indicating a low degree of annexation to the property, they are not firmly affixed to the property but are simply hung, which typically suggests that they are movable items or chattels that were not permanently attached to the property. This implies that the paintings did not form an integral part of the property itself and rest on their own weight. This principle is supported by the case of Holland vs. Hodgson, where the defendant owner of a mill convey the property to the plaintiff by way of mortgage to secure the repayment of a loan. The conveyance expressly included buildings, a steam engine, and all other fixtures whatsoever attached to the property. Over 400 looms were installed in the mill, fastened to the floors with nails for stability but could be removed without significant damage. The court determined whether the looms were fixture or remained chattels. Relying on precedents set by the Wilshire v. Cottrell case, the court concluded that items resting on their own weight were regarded as fittings unless there was an intention to make them part of the land. Now, to determine the purpose of annexation, we consider why the paintings were hung in the first place. If they were hung primarily for the personal enjoyment of the occupants or for convenience, they are likely fittings. However, if the paintings were part of an intentional designed to enhance the aesthetic value of the property and are integral to its decor, then they might be considered fixtures. In Botham's case, Mr. Botham had failed to keep up with mortgage repayments and the bank took possession of his flat. Therefore, any fixtures should be passed to the bank, but chattels will have to be passed back to Mr. Botham. The Court of Appeal held that unremovable items such as the bathroom fittings, kitchen sink, and marble wall panels were deemed fixtures, while light fittings items such as the curtains, carpets, and kitchen appliances were considered chattels. Therefore, Roch L.J. stated that if items affixed are objectively intended to be temporary and for the purpose of enjoying them as items themselves, rather than as part of the land, it remains a chattel. Additionally, Inlay v. Taylor determined that tapestries affixed to walls for decorative purposes were considered chattels because they could be removed without damaging the property, similar to how paintings might be treated. Moreover, the case of Berkeley v. Paulet found that paintings and other decorative items were fittings because they were not integral to the property's architectural design and were for personal enjoyment. Therefore, in Abram's case, it appears that the paintings were not hung as a part of an intentional design to permanently enhance the property's aesthetic value. The fact that they are described as removable suggests that they were intended for personal enjoyment rather than permanent fixtures. Therefore, it is evident that the paintings are fittings and can be removed as they are not part of the land. Now, let's see for sculptures. Since the sculptures are described as extremely heavy and strategically placed to enhance the property's aesthetics, suggesting a higher degree of annexation. However, the key factor is how they are affixed to the property. Here again, according to Holland v. Hobson, items resting on their own weight are generally considered fittings unless there is an intention to make them part of the land. This is reaffirmed in Elistone v. Morris, where it was noted that a wooden bungalow rested on its own weight on concrete pillars, which is constructed using chipboard ceilings in such a way to be removable. That item not attached to the land but resting on its own weight is typically a chattel, unless its removable will significantly damage the property. Hence, in Abram's case, even though the marble sculpture were not attached to the land, but due to their heavy weight, there is a possibility that removing them could damage the property. However, the case of Ham v. Spygraph was similar to this situation, where the defendant sold her house to plaintiff, and before the completion, seller removed some of the heavy garden furniture, such as the stone hearth, the stone statue, and a lead-to, which were resting on their own weight. The purchaser argued that those items were fixtures. The court applied an annexation test and noted 3 facts suggesting the sellers saw the items as fixtures. Firstly, they were listed in the agent's particulars. Secondly, the seller had offered to exclude them and reduce the price. Thirdly, the seller's solicitor stated the furniture was included in the sale. It was held that the defendant was extolled from denying the items were part of the property, as the plaintiff had relied on the agent's particulars. This case highlighted that even items resting on their own weight can be considered fixtures if they are intended to be a part of the property. Now, for the purpose of annexation, the sculptures were strategically placed to enhance the property's aesthetics. This suggests an intention for the sculpture to be integral to the property's design, aligning with the principle from the Enfort, where it was held that items integral to the architectural design such as wallpaper, the statue, the garden seats, and the vases were considered fixtures. The case of Ray Valley supports the notion that items forming an integral part of the decorations are fixtures. Therefore, in Abram's case, it appears that the marble sculptures were intended to be an integral part of the property's design to permanently enhance its aesthetic value. The strategic placement and their heavy weight suggest that removing them could damage the property, indicating they were meant to be permanent fixtures. Consequently, the sculptures are likely to be considered fixtures and should remain part of the land. Now, moving on to the agreement between Abram and Brenda. Firstly, let's see about the intention of the parties. Brenda's later assertion that the paintings and sculptures were mere chattels and not part of the property suggests that she did not intend for them to be included. A statement that common sense will dictate their exclusion underscores a belief that these items were separate from the property. Meanwhile, Abram likely intended to purchase a property that included the paintings and sculptures, as suggested by his interest in their inclusion during initial negotiations. His willingness to consider the high purchase price indicates that he placed significant value on these items being part of the property. Now, how Abram can claim? Abram could justify his positions by referencing the case of Taylor v. Hammer. In this case, Mr. Taylor purchased a property that included valuable antiques, flagstones in his landscape gardens. Before the contract was finalized, the vendor's husband secretly removed the flagstones without informing Mr. Taylor and covered the area with grass. Initially, the trial judge ruled in favor of Mr. Taylor based on deceit but rejected his contract claim, citing the buyer's presumed inspection before the contract extension. On appeal, the Court of Appeal overturned this decision, affirming that the flagstones were part of the property sold to Mr. Taylor. Consequently, Mr. Taylor was granted the right to retrieve the flagstone and receive damages for their removal and relaying costs. The court underscored the buyer's reasonable expectation that observed fixture during property viewing will be included in the sale unless explicitly excluded or expressly mentioned as being removed. Similarly, Abraham could argue that he reasonably expected the paintings and sculpture to be included in the sale based on Brenda's statement about discussing the inclusion if he sealed the deal immediately. If Abraham can demonstrate that his decision to purchase the property at the stated price was influenced by his belief that the paintings and sculpture were included, this might favor his case. Additionally, Abraham could argue that Brenda's vague response could potentially be considered a form of misrepresentation, even though she did not make an affirmative false statement, especially if Abraham relied on a statement when deciding to proceed with the purchase. The case of Esso Petroleum vs. Marden illustrates how unclear or misleading statement made by a party with superior knowledge can lead to a finding of misrepresentation, particularly when the other party relies on this statement to make a significant decision such as entering into the contract. Moreover, Brenda may have had a duty to disclose the truth about the paintings and sculptures, especially since Abraham explicitly asked about them. The principle of Kevin emptor, let the buyer beware, generally applies during negotiations, implying no inherent duty for parties to disclose material fact to one another. However, there is an exception in fiduciary relationships where one party, the fiduciary, must act in the best interest of the other party, the beneficiary, and disclose the material fact that could affect the beneficiary interest. In the case of Nocton vs. Lord Ashburton, it was established that a fiduciary must fully disclose relevant information to the beneficiary. This principle applies in Abraham's case as both Abraham and Brenda share a fiduciary relationship. Given that Brenda is a beneficiary, knew Abraham's concern being the trustee, when he asked about the paintings and sculptures before the purchase, she had a duty to disclose the truth about the material facts. Therefore, Abraham could argue that Brenda's failure to clearly disclose that the paintings and sculptures were not included in the sale constitute pre-contractual misrepresentation by non-disclosures. Now, what are the possible challenges or outcomes that Abraham may anticipate? If Abraham can prove that Brenda's vague statements were intended to induce him into the contract and that he relied on them to his detriment, he may have grounds for claiming misrepresentation and rescind the contract. However, the court will consider whether it was reasonable for Abraham to rely on Brenda's pre-contractual statement, especially when the sale and purchase agreement were silent on this issue. Since they never finalized the inclusion of the paintings and sculpture in the agreement, proving misrepresentation could be challenging. The absence of a written clause regarding the paintings and sculpture in the sale and purchase agreement might weaken Abraham's position. Moreover, if Abraham is unable to provide sufficient evidence on the intention of including the items, it may be difficult to enforce their inclusion. So, as a conclusion, the paintings are likely fittings and the sculptures are likely fixtures. Brenda's ambiguous response and Abraham's reliance on the statement suggest potential ground for misrepresentation. However, without clear evidence of an agreement, Abraham's challenge lies in proving the items were intended to be included in the sale. The outcome will ultimately depend on the court's interpretation of the evidence and the intention of the parties. That's all from me. Thanks for watching.